Welcome to this explainer. Okay, today we are going to untangle a seriously complex legal showdown. We're looking at a massive 800-paragraph constitutional court battle out of South Africa, and it's a fascinating one because it pitted the government's desperate drive for affordable medicine against the literal survival of the pharmaceutical industry. So it's a story about this massive, overarching plan to fix a totally broken healthcare supply chain, the absolute procedural chaos that exploded when that plan was challenged, and the delicate, almost surgical constitutional intervention the highest court had to perform to fix the whole thing. To help us navigate this incredibly dense mix of constitutional law, procedural disputes, and economic policy, we'll follow this roadmap. We're covering the core healthcare conflict, procedural drama and jurisdiction, administrative action and PAJA, the single exit price, the dispensing fee flaw, and finally, the court's final remedy. Let's jump right into Section 1, the core healthcare conflict, which is really a clash of valid interests. Now, before we get into the weeds, I want you to think about this question. How exactly do you lower medicine prices without bankrupting the very pharmacies that sell them, right? It sounds like a basic math problem, but honestly, it's an absolute policy minefield. The real-world stakes here couldn't possibly be higher. I mean, get the answer wrong, and either everyday people can't afford life-saving drugs, or the pharmacies that distribute those drugs are forced to shut their doors entirely.
You see, this wasn't just a simple case of good guys versus bad guys. On one hand, you've got the government's constitutional duty. They are absolutely obligated to try and provide access to affordable healthcare, which they attempted through the 1997 amendments to the Medicines Act. But, on the other hand, you have the pharmacy's survival. These are real businesses that require fair remuneration to stay afloat. And the thing is, neither side is wrong here. The government isn't wrong for wanting cheaper drugs, and the pharmacists certainly aren't wrong for needing to pay their bills. We have two deeply valid, legally recognized interests that just completely collided over these new pricing regulations.
All right, moving to Section 2, procedural drama and jurisdiction. Basically, the race to the Supreme Court of Appeal. So, when these pricing regulations were finally published, the legal fight didn't just casually stroll into the courtroom. It practically sprinted. What followed was this urgent, chaotic dash through the lower courts. Now, the legal system is usually known for moving at a glacial pace, right? Not here. In April 2004, the pricing regulations are officially promulgated. Barely a month later, in May, pharmacies launch an urgent high court challenge because the new rules are set to kick in within weeks. Fast forward to November, the case leaps to the Supreme Court of Appeal. And by March 2005, we're already at the ultimate showdown at the Constitutional Court. Now, you might be wondering, how did it leap to the Supreme Court of Appeals so incredibly fast? Well, that brings us to a brilliant piece of legal maneuvering. See, the High Court had heard the initial challenge, but then they just delayed. They sat on it, taking months to issue a ruling on whether the pharmacies could even appeal. So the Supreme Court of Appeals stepped in using a concept called constructive refusal of leave to appeal. Essentially, they ruled that waiting an agonizingly long time for a lower court to rule on an urgent matter legally counts as a no. That clever move allowed the higher court to take jurisdiction immediately to prevent irreparable harm.
Which takes us to Section 3, administrative action, in PAJA, the rules for making rules.
Okay, before the courts could even start checking the math on these medicine prices, they had to answer a foundational legal question. When a government minister actually makes these regulations, what rules do they have to follow? Enter PAJA, the Promotion of Administrative Justice Act. PAJA is essentially a law ensuring that government decisions are lawful, reasonable, and procedurally fair. It effectively codifies the Constitution's administrative rights to stop the government from just making arbitrary rules. And in this case, 5 judges ruled that PAJA absolutely applies to the Pricing Committee's regulations. They couldn't just invent prices out of thin air. They had to follow a fair, rational process.
So let's look at the actual economics. Section 4, the anatomy of the pricing system, breaking down the supply chain.
To understand what the government was trying to fix, you have to know that the pharmaceutical supply chain before 2004 was an absolute mess. It was full of hidden discounts, obscure markups, and practically zero transparency. The single exit price, or SEP, was designed to fundamentally change how medicine is bought and sold. Before the SEP, drug companies could offer these secret volume discounts to massive pharmacy chains, while turning around and charging small rural pharmacies top dollar. The SEP completely wipes that out. It mandates one single, transparent, legally permitted price that a manufacturer can sell a specific medicine for. So, no more backroom deals. Let's walk through exactly how this new pricing system mathematically builds the final cost to the consumer. Step 1, the manufacturer sets the baseline single exit price. That's the starting point. Step 2, the wholesaler or distributor, the folks moving the boxes from the factory to the pharmacy, they add a tightly controlled logistics fee. And finally, step 3, the pharmacist adds a specific professional dispensing fee for their expertise and service. It's designed to be a highly controlled, incredibly transparent ladder. But here's where things fell apart. Section 5, the dispensing fee flaw. When appropriate, misses the mark. The government's carefully constructed system hit a massive legal brick wall right at that final step. You see, the Medicines Act required the government to set an, quote-unquote, appropriate dispensing fee. But under Regulations 10 and 11, the fee the committee actually came up with was so incredibly low that it tapped pharmacists' incomes to a point where specialized pharmacies suddenly found themselves operating at a severe loss. And legally speaking, a fee absolutely cannot be considered appropriate if it actively destroys the very businesses needed to distribute the medicine. The Constitutional Court looked really closely at the evidence for this, especially regarding specialized sectors, because dispensing fees were legally required to be viable, and they just weren't. Rural pharmacies, which serve isolated communities, risked total closure. Courier pharmacies, the ones delivering chronic medications straight to patients' doors, they faced immediate bankruptcy under this new math. The court recognized a huge paradox here. The government was trying to increase healthcare access by lowering prices, but bankrupting rural and courier pharmacies would ironically harm the public's constitutional right to access healthcare, simply because, well, there'd be nobody left to hand them the pills.
This brings us to Section 6, the court's final remedy, a surgical intervention.
So what do? How do you fix a system that is, say, 90% effective but 10% catastrophic? Well, the Constitutional Court acted with a scalpel, not a wrecking ball. They came up with a brilliant surgical compromise. They validated the overarching transparent pricing system, the single exit price mechanism, and the government's fundamental right to control prices. The core policy survived. But they totally invalidated the specific dispensing fees that were going to bankrupt the pharmacists, forcing the government back to the drawing board. They also struck down some unlawful delegations of power to the Director General and fixed a few minor regulatory issues like failing to include VAT or transparency parameters. It was just a highly balanced legal cleanup. Chief Justice Chaskelson really hit the nail on the head and summed up the philosophy of the ruling with this powerful quote. He said, "This case is not about the wisdom of government policy. What courts are concerned with, and what this case is about, is whether the regulations have been made in accordance with the Constitution and the law." And that is such a vital reminder. In a democracy, the court's job is strict constitutional compliance. It's not their job to pick sides on economic policy. It's literally just their job to make sure the government follows its own rules. Which leaves us with a final, really provocative thought to consider. How will this incredibly delicate balance between affordable medicine on one side and viable pharmacies on the other, how will that shape the future of healthcare? Because this tension, it's not going anywhere anytime soon. As long as we need life-saving drugs, we are going to need a fair system to price them and a healthy, functioning industry to actually deliver them to us. I hope this explainer helped you grasp the profound complexities hiding behind the price tag on your prescription. Thanks so much for joining us, and keep asking those big questions.